You ever wonder what you need for a real estate closing? Everything's about to be explained. Hey, what's up guys? Today I'm here with Harry Marsh from Harry Marsh Law, and we're going to talk about real estate closings. We're going to explain everything to you guys so that you know exactly what's going on. First things first, Harry Marsh, welcome to the channel.
Thank you.
Appreciate you taking our time to educate my users on what goes into a closing. So as an investor, right, and my channel is probably 90% investors and some people who just want to get one investment / primary residence. But we have to deal with an attorney in North Carolina by law, or a title company, depending on where you're at. And I'm on the outside looking in. So both you guys essentially do the same thing. Make sure that the end user gets a good title. With that being said, with a real estate closing, right? As a retail buyer, so the retail buyer, there's a realtors involved and there's a seller and buyer contract. Once I give you the seller and buyer contract, what else do you need? And what's the process?
I tell people to think of it in terms of documentation. Think about a title company or a closing firm, whichever it may be, in whatever state you're in. There are multiple people at each firm. There's a closing, pre-closing, there's a post-closing, there's a payoff department, there's an attorney doing the title search, there may be abstractors, there might be 10 or 15 people looking at each particular closing. So what your job is to document things as well as you can. You need a buyer information sheet, you need a seller information sheet, you need a contract, you need an assignment, you need all of those documents. You might need a commission letter, how much the realtors are getting paid. Your goal is to make everything be put in writing so that the title searcher can see things quickly when they open a file and look at everything. The paralegal can see everything quickly. All those different people have full transparency and can jump into a file and do the little step that they're responsible for so that it can move along in the chain and in the process. And every law firm, every title company does things a little bit differently. The better documented and more organized you can be, the more likely it is that you're not going to have a problem on the back end when that title company is trying to push something through. If they can't figure out who your buyer is or how to contact them or what their email is, things like that can give you a substantial delay. Something as simple as having a buyer contact information sheet, what their phone number is, what their email address. That can save you a week sometimes from a paralegal that is opening a file and doesn't have that information and has to email you in a couple of days, coordinating back and forth. So think of everything in those terms, that this is about trying to make reproducible results for you to make the title company or the closing attorney be able to do things efficiently and quickly.
With that being said, right, so now let's say this is a retail closing. You have your seller's contract, you have your buyer's contract. Now, is there a set of fees across all attorneys, or it varies per company?
It definitely varies per company. The sheet in front of me is actually our sheet of fees. There's usually kind of an industry standard in a particular state or in a particular area that you're in. But even among our area, Charlotte, the Charlotte fees are different than the fees for a more rural area, 4 counties over. But roughly, you're expecting the seller to be responsible for between $300 to $500 in closing fees. That's what the attorney makes, for preparing their deed, all the things the seller needs. The buyer, on the hand, somewhere between $700 to $1,000 in attorney fees, depending on whether it's a cash deal, which is easier than a loan deal, or if it's a finance loan. A finance loan might have 100 pages of documentation that they need and some extra things to jump through. That's why that's a little bit more expensive. So from the wholesaler, investor, buyer perspective, maybe you want to say in your contract that buyer pays all the closing fees. That's typical to do so that you can kind of tell the seller, look, you're going to walk away with X amount of dollars. And if you're going to do that, you just need to be responsible for that extra $300 or $400 that the sellers would have normally paid. There are 100 different variables that can change how much your closing costs will be. That's honestly the job of the paralegal. That's what takes them sometimes a couple of days to figure out doing the HUD. For example, something as simple as an HOA. If there's an HOA involved, there might be a certification fee, $200 just to get a copy of the HOA documents to see if they're behind in it. There might be an amount that the HOA requires you to pay, towards like a pool or something. You can have thousands of different possible fees in a closing, and that's what takes so long for the paralegal to do. But roughly, the attorney fee is $700 to $1,000 for the buyer, $300 to $500 for the seller. You should be able to tell people under $1,500 you can do a closing. That doesn't count, property taxes being prorated or split. I wouldn't really call that a closing fee, but it's something that goes on the HUD that people don't think about. If property taxes are $3,000 for the year and you close in the middle of the year, the seller should be responsible for their share of that $1,500. That's going to be on the HUD, and that can, make things look substantially different. You might be expecting $1,500 in costs, but the actual HUD says $4,000. After you pay the HOA certification, you need down payments like that, property tax prorations. Recording the deed is something that costs sometimes between $200 and $500, depending on the value of the property. It's the purchase price divided by 500. That's a tax you pay to the county. So I wouldn't even call that a closing cost really either. That's not something the attorney makes or anything. That's more like a tax that the county is charging. So whether you're putting the buyer responsible for that or the seller responsible for that can make the changes or the closing costs go up or down.
That finance paperwork sometimes from the financing company, it's a book. Yeah. All right, it's probably about this thick sometimes. So you or your team, one of you guys had to actually read through that?
Your standard documents.
Okay.
Every loan company has a generation program. They just plug in their information and it spits it out. So a lot of the times we've seen the particular loan documents like 100 times.
Gotcha.
That's what we do at the closing table. We go through them carefully with the buyer and explain if they have any questions. If we see anything that's out of the ordinary, we would raise a question or talk to them about it.
All right, that's the retail side, but on the investor side, right? And I got a lot of people on my channel, they are wholesalers or they're cash buyers. So on the investor side, right, I'm assuming you need the sellers, you're gonna need the original contract between the wholesaler and the seller, deposit from the cash buyer, and the assignment, all right? The assignment and the deposit from the cash buyer. So once you have those documents, you will then at that particular point, you can start title. Or what do you need to start title for a wholesaler and investor deal?
A lot of the times people use us because we'll start title immediately. You can just call us and even give us an address and we'll start title. It doesn't mean that we can do title though without sometimes talking to you and getting more information. North Carolina is a weird state where you're not always required to have a deed. When someone passes away, for example, their heirs, their children automatically own the property. But there's no deed that's recorded down at the courthouse that says that they own the property. So we can do a title search on any property and I can tell you who I think owns it. So I have an idea and I can complete the title search, but I'm waiting for you to give me that information sheet that says this person is dead. Here are the 3 heirs that actually inherited the property. So a lot of the times we can do the full title search, but most law firms will want you to submit what they call the seller information sheet before they will do the title search. And that is the reason they're doing that. They want to know if the person is dead or if inherited or has a wife that should be on the deed or isn't on the deed or if they're married or not. There's a lot of questions that seller information sheet will give them, including do they have an HOA, do they have a mortgage, all these things that they can verify in the title search. But we can do a title search immediately and without any information. It's just usually, again, the law firm's different procedures require that you have all that information in place before they will even do the title search.
Okay, so, and with the seller information sheet, I've done so many closings with you guys. I have your seller, me and my partner, DeAndre, we have your seller information sheet saved somewhere so we know to automatically give it to the seller. But to the new person is gonna use, Harry Marsh Law, is that on your website, the seller information sheet, or do you wanna email it to them?
Yeah, we have an online version of the seller information sheet. Someone can even fill it out on their phone, or we can email you a copy. A lot of the advanced investors have that seller information sheet on hand, so they give it to them along with the contract. Because something like that can save you a week. If you fill out the contract, get it signed, it might be another week before you can get out to the seller and get a handwritten, signed seller information sheet. So things like that can really save you a lot of time. We can do a closing within a day if we have all the information up front.
And that's why a lot of the investors that I know of in the Charlotte market use you, because you can close quick. Whereas some firms you go to and they might say, all right, today's the 15th. I may could get you in March 1st or, February 1st. You're like, I need it done now. They're in pre-foreclosure. So.
And this aggressive market, if you wait a while, you've got 5 other people trying to buy the house.
Absolutely.
It's every day we get multiple contracts on the same property. They're out there trying to take the highest offer.
Okay.
So the faster you can close, the more likely you are to lock them down.
Yeah.
Yeah.
Now you brought up something that I hear a lot, and so if I hear it a lot, I'm quite sure you probably hear it about 1 million times a week, which is, hypothetically speaking, in North Carolina, it takes 1 to buy, 2 to sell. So a husband or wife, let's say they've been separated 5 years, right? And they don't talk to each other, kids are grown. So therefore, when they want to sell a piece of property and they come back and we come back with, hey, you married? No, not really. Oh, you divorced? No, not really. We are, I haven't talked to them, since 2016. And so, okay, well, this person has to sign at closing for you to sell this property. And regardless of the situation, the first thing I always get, they're not on the deed. I want you to go just dive deeper in depth of them not being on the deed, but they have to sign because they have an interest in that property, and therefore they get title insurance. You need title insurance to get a good marketable chain of title. So how do you find that out that somebody's not on the deed, but they have to sign? Is that like a state law thing, or what's involved with that?
I did family law for a year or two, and that's probably where you need to start to explain that. We're a marital property state, where basically whenever you buy anything or anything you own could arguably 50-50 be owned by your spouse. So whenever you get a divorce, they have a procedure called equitable distribution. That's basically the fight that you hear about when you're getting a divorce. You go in front of a judge and say, I want this, you want that. You're splitting up all of your assets. That's the big, trial in a divorce, who gets what. From a title company's perspective, they want to reduce risk. They don't want a lawsuit filed. Just the cost of litigation and attorneys and defending yourself, even if you're completely innocent and in the right position, can be substantial, $20,000 or $30,000. So from a title company's perspective, if there's no divorce, they're basically married. And that's when I teach title searchers, I say, if it says separated, they're married. If they don't know, they're married. They're married until they prove otherwise. And there's a court search we can find. If they're divorced, we can very often see a divorce under their name. So that's easy usually for us to tell. A lot of the other times, mortgages and things like that will actually indicate whether the person is married or not. So It might only be one person on the deed, but the mortgage or the deed of trust in North Carolina says that they're a married person. So we can kind of get tipped off that they're married. But basically, unless we have a divorce, that spouse can come forward at any time and say, I own 50% of it, whatever you own. It could be the situation that spouse comes forward and says, I'm the one that paid the down payment on this house. I put 50 grand into it. I want my 50 grand back. And if they're ever going to get divorced, they have that equitable distribution trial, and then suddenly they're arguing about $50,000 of equity in the house, and it gets dragged into a lawsuit about that. The title company has to defend. They might have to pay the claim. They might, either way, they're going to pay their own attorneys. So from a title company's perspective, they want to make sure that there is no spouse coming forward stating that they are owed money out of that situation. So that's why they make the spouse sign, even though they might not be on the deed. It's very common in an equitable distribution trial for the spouse to say, I'm the one that made the mortgage payments, for example. Yeah, he's on the deed, or, but I inherited this property maybe, or I paid all the payments, or I'm the one that put the new roof on it and I want paid back for that. So what they're doing is, mitigating the risk. You can do a closing without a spouse. It's just hard to get insured by a title company because there's always that risk that the spouse goes forward. Clever investors will sometimes buy a property without the spouse interest signing off on it. And they're getting rid of their inchoate. Inchoate means it's not really there. It's not a real thing. Marital interest. If the person later gets divorced, divorce cuts off that interest, kind of severs the marital interest, and you can get good title later. So, for example, you could buy a property without a spouse, so kind of bad title. But if that person you bought it from gets divorced next year, and no one comes forward wanting the house, then you're good. Okay. So you have to document that divorce or get the person to sign off on it if you want a title company to cover.
Just because someone's name is not on the title does not mean that, there's nobody else that's involved. That's the point I was trying to get. Now, one more question.
One more thing, Dad.
Yeah.
Sorry. There are a couple rare judgments and liens that actually attach to you, even if they're against your spouse. So that's another issue and reason why title companies want the spouse to sign off. Like IRS liens and hospital bills and stuff like that, they can be against your spouse and they can collect from you. Really rare, but that's another reason title companies want the spouse to sign.
I remember years ago, I would never forget this deal, whereas it was a husband and wife. The wife inherited some vacant land walking distance to the water in Belmont. We were gonna wholesale it, so wasn't gonna buy. I wish I would have bought it, but I believe we had it under contract for like 18,000 or so, and it was in walking distance to the water in Belmont. And just to put in perspective, guys, today that lot's probably worth about 200K or so. We went to do title search. When we went to close, they've been married two or 3 years, and he had a IRS judgment prior to them being married. And it did not matter because she was selling it, and being that they were married, the IRS wanted some money, and she was basically like, hey, I'm not paying for his mistakes. I'm not paying for it. And we couldn't close due to that. Yes, title can sometimes get tricky. It's, from the outside looking in the general public, we think, well, if they're not in the deed, they're okay, which that's not reality, is not the proper way for law.
And that goes back to all that documentation and the seller information sheets. The title company might not be able to do a title search because they might not know the name of the spouse, because the name of the spouse might not be on the deed. So that's why you got to get all that information in. That's why sometimes title companies don't do the title search until they have all that information.
One more thing, Harry, if somebody were to get a prenuptial agreement before they got married, right? Do their spouse still have to sign off on those type of deals?
There's something called a free trader agreement, which basically states that the husband and spouse are separate for anything that they buy, or maybe a prenuptial agreement stating that anything that they owned before the marriage is separate. So yeah, there's something called a free trader or that prenup. It's just language that basically states exactly that if there's an equitable distribution trial, these things are not counted in that. They're the sole property of one person. Okay. So yeah, you can do that.
Yeah, because I had a seller, I'm not gonna say his name, but he owned a lot of stuff in Charlotte, and we were closing stuff, and they mentioned, hey, you're married. Oh, nope. And he emailed in his prenuptial agreement and everything, and we were able to smoothly close the transaction, man. But Harry Marsh Law, a lot of investors in North Carolina watch my stuff. I know you do stuff all over North Carolina, but how do people find Harry Marsh Law?
North Carolina and South Carolina. We've got a website that you can get to, just harrymarshalaw.com. Text, call. I do answer my phone. I'm pretty easy to get a hold of. I know your life and what you're going through, trying to get deals done. That's my job, try to help investors. We are more investor focused rather than the traditional realtor kind of stuff. Realtor kind of stuff is easy, we can do that too, but we help a lot of the local investors.
All right, guys, there you have it. We're wrapping this up. Real estate closings explained. Hopefully that was helpful. Hopefully you can reach out to Harry Marsh Law with your next investment deal or investor deal to get closed. And in the meantime, click on the video next to me, and I will see you guys in the next vid.